Good morning, everyone. My name is Christian Waugh, and we are here for the January 2023 Citrus County Code Compliance hearing. The time is 9:01, and I hereby call this hearing to order. We follow an agenda, and the first item on the agenda was the call to order. The second item on the agenda is the pledge to the flag. So I would ask if you join me in the pledge to the flag. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you, everyone.
Good morning.
Good morning.
If any person decides to appeal any decision made by the Code Compliance Special Master with respect to any matter considered at this public hearing, he or she will need to ensure that a verbatim record of the proceedings is made, which record shall include the testimony and evidence upon which the appeal is to be based.
Thank you. The next item on the agenda is approving the minutes from the December 21, 2022 hearing. I have reviewed the minutes and have no proposed modifications or objections. Are there any objections to the minutes as they've currently been formulated? Okay, hearing none, I hereby approve the minutes.
Staff update: abated and continued cases are posted out front.
Okay. I'd now like to make a brief opening statement for your all benefit to understand a little bit better about how this hearing is going to go and the process that we typically follow. My name is Christian Waugh, and I'm a licensed Florida attorney acting as what is called a special master. That's a fancy title created by the law, but what it means is that Citrus County has hired me to preside over this hearing. When your case is called, I'll ask you to come forward and ask you to be placed under oath. If you are appearing at a hearing like this for the first time, I'll state the alleged violation against you and allow the county to present its case. You will then have an opportunity to present your case regarding the violation, which may include the presentation of evidence if you wish. During this process, the county attorney's office or myself may have questions of the parties, witnesses, or staff. I will ask if there are any members of the public who wish to speak, and if there are, such members of the public will have one opportunity to speak per case. Such right to speak is not unlimited, and public comment should be focused on the case and made as succinctly as possible. It is not an appropriate forum for personal attacks. In most instances, if you are found guilty of a violation, the law requires that you be given a time to comply before any fine begins. You must abate the violation by that date, that is, fix the violation, or the fine will accrue for each day that you remain in violation. The law then allows Citrus County to impose that fine as a lien on all the property you own, and the county may foreclose on that lien or seek a money judgment against you after the lien has been recorded for 3 months. This is important because I may not give you another time to appear before me, and therefore you likely will not have another opportunity to plead your case or to explain why you didn't comply with the county law. The county will continue maintaining its liens against your property until you notify the county of your compliance. In all cases in which I find someone guilty of a violation, I'll impose all costs required by county law. If you abate or fix the violation in the time allowed, that cost will remain minimal. If you do not timely fix the violation, you'll be responsible for additional costs as well as the cost of the lien that is imposed. If I find you guilty of a violation and allow for a continuance of your case, you will be required to return on a certain date. In the time between hearings, I'll require that you comply with the county law in order to consider that the violation is resolved. If your violation is not resolved by that next date, I may impose a fine for each and every day of the violation from today's date forward. Your failure to return on the date may be deemed evidence of your failure to cooperate with the county. Do we have any appeals? All right. Ladies and gentlemen, you do have the right to appeal any order that I make today as provided by law. Thank you.
First case on the agenda will be Dennis W. Marshall, case number 217-3314, Code Officer J.C. Charlton, page 18 of your agenda.
Morning.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Mr. Coy, can you please announce yourself and who you're here for?
Yes, ma'am. Brian Coy on behalf of Imelda Marshall, and I'm an attorney here in Florida.
Great, thank you. How do I spell your last name?
Coy, C-A-U-G-H-E-Y.
C-A-U-G-H-Y.
E-Y.
E-Y. Okay,
We
thank
got
you.
all the vowels.
Good morning.
Good morning.
J.C. Charlton, Citrus County Code Compliance Officer, case number 217-3314, special requirements for all accessory structures in violation of Citrus County Land Development Code 3102A. The address is 6716 South Wall Point, Homosassa, Florida. Property owner Dennis W. Marshall would like to authenticate the following documents and request it be admitted into evidence. Exhibit A, photos taken during an initial inspection on September 20th. Follow-up inspection, corrective action inspection on December 14th, and photos of final inspection conducted on January 17th, 2023. Exhibit B, a copy of the notice of violation, notice of hearing, a copy of the property appraisers listing the property as vacant.
Let me ask Mr. Coy.
Yes.
Coy first. You say you were here on behalf of Imelda Marshall?
Yes, she's here.
And is Imelda an owner of the property or an occupant or?
So that's a very pointed question. The property was owned by her husband, Dennis Marshall, in solely his name. He has since passed. So theoretically, the owner would be the theoretical estate of Dennis Marshall. There was no probate done on the property until probably 2 weeks ago, where Miss Marshall came in to get this problem addressed. But because Miss Marshall doesn't have standing to do either an eviction or an unlawful detainer or an ejectment on the property, not being an owner, she can't do anything to fix the issue.
In other words, she's not the source of the violation.
She's not the source of the violation.
There's tenants or occupants of some type who are in possession of the property, who are
Yes.
not her.
Unlawful occupants.
Unlawful occupants.
So what we're doing to remedy the issue is we have opened up a probate.
Yeah.
That case number is 2023 CP 45. It is a summary administration, so they should
Okay.
move pretty quickly.
Yeah.
The minute that we get the legal authority to go forward on an unlawful detainer action, we certainly will.
Well, importantly, there's certain rules about standing and who can stand at that podium. I do find that she has standing if Mr. Marshall's deceased. I assume you'd represent that she's the sole
She's
heir.
the sole beneficiary.
Okay.
Under the will. There was a will.
There
There
was
was
a
just
will.
no
Okay.
probate done because everything went to her.
Did
and
he
she
pass
died.
over 2 years ago?
I believe so.
Okay. And a summary admin would work. I don't know if you care to make comment about this, but normally what I ask the defendant or the respondent, so to speak, is to take a look at these documents and let me know if they have any objection to them being evidence.
I don't have any objection to
Okay.
under the evidence.
You're familiar with what's going on
I
in the
am.
property. All right.
And what we're really asking for is if we could have 120 days to get in compliance.
Okay.
That way we can get the probate wrapped up and we can get the unlawful detainer action wrapped up.
Okay. Thank you. Without objection, what's been proposed as Exhibits A and B are evidence. Is there anyone from the public who's going to want to be heard on this case? All right. Let the record reflect there's no response.
An inspection was conducted on September 20th, 2022. Photos depict a camper, a car, and other items on the vacant property. I've had contact with the property owner's wife and explained the violation. As of my final inspection on January 17th, 2023, all items remain on the vacant property.
Is there anyone else from the county who wishes to testify?
Yes, Joanna Coutu, Land Development Director.
Good morning. It is a RURMH, Rural Residential Mobile Home Allowed site. I could find no abutting addresses that possibly could be moved with this, so it should be vacant.
What do you mean moved with this?
There's RVs and tents and things, and if they have an abutting property, they might be able to move the RV.
just shift it. I
Right,
see.
right. But it's not. It came up a lot last hearing date. Not a possibility here.
I got you. Okay. Let me just take a look through these documents, make sure I can understand what's going on. Is that a Mitsubishi 3000 GT?
think. I'm not 100% sure.
That's impressive if so. Haven't seen one in a while.
It's a
car.
yeah,
See,
it's
I
a-
don't know.
I knew it was a Mr. Beachy.
Does the county have any health sanitary concerns?
Not that I'm aware of. I think environmental was notified, but they didn't find any.
Okay. Then what I'll do is here's what I'll do. Do you have any other comments you want to make,
No.
Mr. Coy? All right. I do find that the property is in violation. I'll grant 120 days from today to abate the violation. If the violation, I'm sorry, what's the county's recommendation?
Citrus County Code Compliance Division respectfully requests a special master assess a fine of $50 per day, along with the administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriately given to the severity of the violation and respondent's actions relative to this violation. We'd also ask the special master additionally find that it is respondent's responsibility to contact the Code Compliance Division when this violation has abated to allow for reinspection.
Okay, it is going to be 120 days from today. If the violation is not brought into compliance as ordered, a penalty of $50 per day will be imposed. This fine would be recorded and constitute a lien on the property of the owner, whoever that may be. The county attorney's office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording, and the owner shall be responsible to pay all costs required by county law. Thank you.
And what are you going to look for as far as proof of abatement?
That's a good question. I think what the burden, first of all, is on y'all to get in touch with the county to let them know. But in order to abate, it looks like the offending use needs to be removed. So it's really just I don't know if you want to opine or handle this outside the hearing.
All items removed from the
Yeah.
property.
Yeah.
Is the property cleaned up?
It's got to be
Probably,
cleaned up. No one there, none of the RVs, no accessory use. It's
Okay.
essentially got to be vacant.
Okay, we can work towards that.
Like even a picnic bench really
vacant.
is not, it's not allowed.
Yes,
So
sir. I understand.
does that make sense?
It does.
All right. Thank you.
That's great.
Thank
Thank
you.
you. If I could be excused.
Yes. Thank you.
Next case on the agenda, Melissa Swanstrom. Case number 2176881, Code Officer Jillian Nacella, page 24 of your agenda. Yes. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Jillian Nocella, Citrus County Code Compliance Officer. This is case number 2176881, Special Requirements for All Accessory Structures, a violation of Citrus County Land Development Code 3102A. The address is 11000 West Seminole Place in Homosassa, Florida, 34448. Property owner is Melissa Swanstrom. I have good service via signed certified mail return receipt. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A is photos taken during an initial inspection on November 18th, 2022. Photos from a subsequent inspection on December 12th, 2022. Photos from my final inspection on January 17th, 2023. Exhibit B is a copy of the notice of violation and a notice of hearing sent to the property owner, copy of the signed certified mail return receipt, and a copy of the property appraiser's summary page reflecting the property is listed as a vacant parcel.
Is there anyone from the public who wishes to be heard on this case? Let the record reflect there is no response.
Is this the same owners? Okay, so that's completely vacant.
Without objection, what's been proposed as exhibits A and B are evidence.
An initial inspection was conducted on November 18th, 2022, and it was observed that there was an RV, golf cart, and shed located on the vacant property, which is a violation of the Land Development Code mentioned above. My corrective action inspection was conducted on December 12th, 2022, and in addition to the items previously mentioned, a boat on a trailer, small tractor, and a flatbed trailer had also been brought onto the property. As of my final inspection yesterday, January 17th, 2023, I observed the same items to remain, along with a truck, another trailer, and an additional golf cart. I have not had contact with the property owner or anyone at the property. An expert on this case is Land Development.
Love to hear from any experts you have.
This is CLR MH, Coastal Lakes Residential Mobile Homes Allowed. Our records show it should be vacant.
Okay. What's the county's recommendation?
Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day along with the administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners since they were advised of the violation. This amount is appropriate given the severity of the violation and the respondents' actions relative to this violation. We would also ask that the special master additionally find it's the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
Do you know if it's the same owner of the adjacent lot with the home?
It is not.
It is not. Okay. Was it $50 a day, the recommendation?
Yes, sir.
Okay. I adopt the county's proposed findings of fact. The property is in violation. I'll grant 30 days from today to abate the violation. If the violation is not brought into compliance as ordered, a penalty of $50 per day will be imposed. And I incorporate the standard order provisions. Thank you.
Next case on the agenda, Charles Hamilton and Marie Lorene Hamilton, case number 217-5293. Code Officer Brandon Norman, expert on the case, Carl Jones from the Building Division. Mr. Hamilton? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. Your name, please, for the record?
Charles Hamilton.
Thank you.
Good morning.
Good morning, sir.
Good morning, Brendan Norman, Citrus County Code and Compliance Officer. This is case number 217-5293. Construction or modification of a structure without required permits, a violation of Chapter 18, Article 1, Section 18-8, subsection A of the Citrus County Code of Ordinances. The address is 5572 South Marlin Point, Floral City, Florida, 34436. Property owner listed as Hamilton Charles and Hamilton Marie Lorene. I have good service via posting at the property in the Lecanto Government Building. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A is photos taken during an initial inspection on October 26, 2022. Photos from an inspection on November 28, 2022. Photos taken at my compliance inspection on December 5th, 2022, and photos taken at my final inspection on January 17th, 2023. Exhibit B will be a copy of the notice of violation, a copy of the notice of hearing, and a copy of the posting affidavit I completed, as well as the photos that I posted at the property for the notice of hearing.
Okay. I'd like to ask you to show those documents to Mr. Hamilton. And
Yes,
sir, if you would, just take your time looking through these documents and let me know if you have any objection to them being evidence.
Okay, yeah, those are good. You got one where that's missing. Yeah. Good to go.
You've already looked at it?
Yes, sir. Yeah, we're good.
Okay. Okay. For my own knowledge, is there anyone from the public who's going to want to be heard on this case? All right, I don't see any response.
But that sound like a guest house or something? Oh, what's pretty fancy?
Is that on the record, Ms. Antrim?
Looks cute.
Okay. Without objection, what's been proposed as exhibits A and B are evidence?
On October 26, 2022, an initial inspection was conducted of the property for a shed and carport that was erected, as well as modifications to the home at the property. Research was conducted in Hanson and was determined that no permit had been applied for any of the items talked about above. I was able to contact the property owner. He stated he was unaware that he needed the permits and began to work to rectify the issues. He has remained in contact with me throughout the process. On November 28, 2022, I conducted a compliance inspection and found no change. The property owner stated that he was in the process of obtaining the documentation required to apply for the permits. I advised the property owner he had more time to get his permits or to remove the remaining structures. On December 5th, 2022, I conducted another compliance inspection and found the remaining structures on the property without permits. The property owner has applied for after-the-fact permits for the modification of the existing home on the property. as of 28 December 2022, and they are in processing as of today.
So what all on the property requires an well, actually, so on my January 17th photo, I see that it appears the carport or whatever you want to call it has been removed. Is that your understanding?
Yes, sir.
So that's not an offending.
So the carport is no longer an issue.
Okay.
The only remaining items are for the after the fact permit to be issued for the modifications to the home, and then for an after the fact permit to be applied for the shed.
Okay. From your understanding, I'd just like to know what the county's case is before I turn to you, but is the shed an entirely new structure or was it modified? Do you know?
From my understanding, it's a separate permitting issue for them. So he applied for the initial permit for the house, and then because of the shed being an accessory structure, it's a completely different permit. So
Yes. Was the shed built without a permit or were there modifications to the shed?
from my understanding, the shed was built without the permit.
Okay. And what were the changes on the house? What was done to the house that required a permit?
They added the second story addition to it.
I will add something here that may be helpful to you. Carl Jones, building official. The second story addition permit was applied for in December of 2022. Permit number 17944. It's ready to issue as of January 12th. That permit is ready to issue, pay for and pick
Just
up.
has to get paid for.
It just has to get paid for and pick up.
Wow.
That is correct.
Well,
That's
good
for the
news.
addition. It doesn't address the shed.
Well, I mean, I like to understand what's going on before I rule, but, I mean, was this a one-story home before?
That's what yes, sir. So the property appraiser went out.
It's hard
and,
to tell.
Initially, it was a one-story
okay.
structure, and then they did
Wow.
the second story addition.
Okay. And so no permit has been applied for the shed.
Not for the shed
Okay.
yet.
Mr. Hamilton, you've heard the case. Do you understand what they're saying?
Yes, sir. Yeah, and so also I bought the home as is, as everything stands on the property. So it was all quite a shock. But,
I see. Okay.
And to my original understanding is it was a one-story, almost shoebox. The entire addition on the home was added. The shed, I was told, was built to replace an existing shed. Again, it stood as is when I purchased it. I did remove the carport as stated, and I work out of town, so I didn't do it until this morning. But I have where I've paid and picked up the permits on the domicile and applied for the permits and submitted everything along with supporting documents, hopefully to get the shed cleared.
All right,
up
so
this
I want to
morning.
understand your testimony. You've said that you have paid for and therefore received the permit, the after-the-fact permit on the main home.
Yes, sir.
Okay, I'm not going to find a violation on that, assuming you're willing to share with me
Yeah, absolutely.
the
absolutely.
receipt, and we can put that into evidence.
Yeah, and then the receipt for the application for the shed is on here.
Do you want that to be evidence too?
Yes, sir. Yeah,
I'd like
it's
to
all
ask
on
you
the
to
same
show
receipt.
that to the county, and let's see if they have any objections to those documents being evidence. It seems to be consistent with the testimony we've heard.
No, I'm good with that.
Cool.
That's application
Yep.
fee, and that is picking up now.
Yeah.
Okay.
I would like to caution, I don't know what the precedent has been in the past here, but the issuance of a permit doesn't necessarily abate a violation for an illegal structure. It's the inspection of that structure to prove that it's code compliant, and closing out the permit would be an abatement of the violation.
Well, let's read what the section says. Permits required. Construction of a structure without a valid permit, no person shall erect, construct, enlarge, et cetera, without first having obtained a permit therefore. There is no requirement for an inspection. So if that's going to be a part of it, it's got to be the code has to be amended. I'll find no violation on the home. Without objection, I'll have these receipts admitted as composite exhibit A for respondent. I am going to find a violation on the shed. How much time do you need to? I mean, I know it's hard to say because it depends on you working with the county.
Yeah, and I'm trying to think. Gentlemen had the dates. I was trying to think of how long it took from the time of submitting the plans for the main domicile. I don't know.
Is any
90
engineering
90
required? I know
days.
that's an issue sometimes.
So I had to get engineering prints done and inspections by an architect and engineer to certify that everything was to code.
For the
So-
home?
For the home and as well
And
as
you've
the
done it for
shed.
the shed?
Yes, and I submitted all that. That was done this morning along with the supporting letter. So hopefully everything should be in order.
Well, I have no idea how long the process
I don't know if
takes.
90 days is enough. I mean, that may
That would be
be
my instinct.
sufficient, but I think 90 days would be
What do you think, Mr.
what I would
Jones?
ask. I don't
That's
know.
reasonable.
That's reasonable. Just keep in mind, no one's making any promises about that.
Yeah, no, and I'll try to stay on top of it as much as possible.
Okay.
And
Okay, great. So what I'll do is I'll find that the property is in violation. What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day along with administrative costs to begin after the date that you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask the special master find that it's respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
I'm actually going to read this whole code section just to make sure that I'm going to see what Mr. Jones said. And I guess, Mr. Jones, I guess one question I would have for you is, would you be able to verify compliance with the code in one inspection, or would it take you more than one inspection to figure that out?
Well, there's two scenarios that could come into play in a situation like this. If the plans attest by an engineer and the plans attest to the fact that those drawings are accurately accurately represent what's on site, and the engineer says, I'm certifying that it's compliance, theoretically, we could close this case out with no inspection at all.
I see.
If those compliance statements are not there, then we would go to the site, visually inspect the home to make sure that it matches the plans, and then upon confirmation that it matches, we would make the determination
So in
it's
that
compliant.
second scenario, would you be able to achieve that in one inspection, or would it take more than one?
One.
Okay. Here's a problem for Citrus County then. I'm looking at section 18-8 subsection E, and there's a section that says no inspections. No permit shall be required and no permit fees shall be charged for construction improvements which do not require one or more inspections to verify compliance with adopted codes. Any exemption from permits allowed by this subsection shall not apply to construction work that is part of a larger construction project, which when taken as a whole would require a permit and inspections. Maybe this satisfies that, maybe it doesn't, but I really think we're gonna have to read these cases with an eye towards whether or not.
I can answer your concern there,
Yeah.
and I understand your concern.
Okay.
The Florida Building Code also says that the building official has the authority to require that inspection to be performed by an outside party, which is the engineer. The home has been inspected. In this particular case, we requested that an engineer do it.
Mm-hmm.
So that engineer becomes the delegated authority by the building
No,
department.
that's fine. I mean, I accept that.
So that isn't it. That is, the home did require inspection.
No, so my issue
The permit has been inspected.
That's the issue. So the issue is, I mean, I don't know. It's kind of an interesting code section. It says
It is.
no
It is.
permit shall be required for construction improvements which do not require one or more inspections to verify compliance. So one is okay.
Yes.
I mean, I hear what you're saying. It required one based on the
Right.
engineer. But I don't know. I mean, I just,
every
y'all should look into
inspection,
that.
I'll explain. Every inspection that the building official requires is usually performed by a delegated person.
Right.
Even my staff have delegated authority to act under my license.
Right.
They are my delegated authority. In this particular case, because the structure was already built, we required an engineer to become that delegated authority to perform those inspections.
No, I
because
know.
none of my staff are going to take the responsibility for it.
No.
So-
That's not what I'm
So
saying, Mr.
this
Jones.
building did require an inspection.
You're not understanding what I'm saying, Mr.
Okay.
Jones. Let me explain it to you. Okay. I'm not saying it's on this case.
Okay.
What I'm suggesting is that the county needs to consider this on other cases, because I believe I have heard Section 18-8 cases where inspections may not have been required. So I don't know. I'm not relitigating any of the old cases. I'm just suggesting this is something we'll be looking at going forward.
Yes.
Not on this case.
Well, I will assure you that if I'm aware
Yeah.
of any situation
No.
that would not require inspection,
It won't be
we
in front of
also
me.
would not have required a permit.
Good. I'm glad to hear that from the county's perspective, the county's following the law.
Yes.
Nonetheless, I hope I've made myself clear to the
Yes.
county. Very
We're-
good. So there is no violation on the home. There is a violation on the shed. The county's recommended. Actually, let me stop that. Let me stop that. Mr. Jones made a comment that an inspection would be required on the home, and I think I was wrong on one part of this, which is even though it says that a permit, if you get a permit, you've essentially fixed the problem. And I know in prior cases that's what we've said. I've never heard the inspection requirement until today. It actually makes sense, which is what's the purpose of, a permit if it's not inspected and followed up with from the county, right? So, because maybe it's not constructed in accordance with that. And what Mr. Jones said is, look, if the engineer certifies that it was done correctly, then you're fine. So I don't know the answer to that. I don't know what the engineer has done on this. So I'm going to, but there's no evidence before me that it wasn't. So again, I'm still going to find that there's no violation on the home, but also for everybody in the future. I mean, in order for me to find that there would not be a violation based on engineering being submitted and a permit obtained, I'll incorporate Mr. Jones's comment that we either need a delegated inspection approval or inspection approval from the county itself. Is that the correct understanding? All right, no, but I think that's what I'm understanding as necessary, and I agree with that. So,
And I should have here, I don't know if they give it back to you or not, but the engineer's letter for the inspection. I don't know, is that something
if you
would
have
like as
that,
well?
that's helpful evidence.
Let me check and see if they gave that back
yeah,
to me. I don't
I
know
hate
if
to.
they-
It's just this is kind of the detail.
Yeah, I don't know if they maintain that to keep on file or if they
Mm-hmm.
actually returned it to me this morning, but he did also, pretty much the same letter that he wrote and endorsed separately, he put notes into the print that he had also inspected it. So I don't know if that would help. Oh, nope, looks like it's right here.
If you could show it to the county, I'd be interested to know if it's helpful or not. Assuming it's true and accurate, Mr. Jones.
On the surface,
I'm inter-
after a cursory review,
Yeah.
I would say this answers the question.
Probably. Okay.
It does.
I think that's where we're at. I mean, I'm not gonna. These kinds of cases are still relatively new in front of me. So, so does the county have any objection to this document being evidence? Let Ms. Antrim review it.
Yeah,
That is an original, that is an
Yeah.
original sealed letter. Are you willing to give it up? as
Yes, sir,
evidence?
that's fine.
Okay.
Yeah, because like I said, at this point, everything's been approved. I don't know that I need to maintain it for records at this point, so that's fine.
Okay.
So this is as to the home. and
Just as to
addition.
the home.
Yes.
All right.
No objection.
Okay, then this will be respondents B. I'll just take a look at it. Okay. All right, so we're back to square one. I'm going to find that there is a violation as far as the shed. Sounds like good progress is being made. I'll grant 90 days from today to abate the violation. If the violation is not brought into compliance as ordered, a penalty of $50 per day will be imposed. This fine will be recorded and constitute a lien on the property of the Hamiltons. And I incorporate other standard order provisions regarding, the potential for a lien and being responsible for the costs. Thanks, guys.
Thank you.
Next case on today's agenda, Kenneth G. Burgess, case number 217-2454, Code Officer J.C. Charlton, page 5 of your agenda. Experts on the case, Carl Jones and Joanna Coutu.
Mr. Burgess? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name for the record.
Kenneth Burgess.
Thank you.
Good morning, sir.
Good morning.
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 J.C. Charlton, Citrus County Code Compliance Officer. This is case number 217-2454, construction or modification of a structure without a permit, violation of Chapter 18, Article 1, Section 18-A of the Citrus County Code of Ordinances. The address is 6012 South Morrow Point, Homosassa, Florida. Property owner Kenneth G. Burgess. I would like to authenticate the following documents and request to be admitted into evidence. Exhibit A, photos taken during the initial inspection on September 8th, 2022. Corrective action inspection on October 12th. Follow-up inspection on December 7th and 20th. And my final inspection on January 17th of 2023. Exhibit B, notice of violation, notice of hearing, copy of the continuance letter notifying the owner of today's hearing, copies of the signed certified mail return receipt for the notice of hearing and continuance letter.
Okay. Mr. Burgess, you've seen kind of how this runs already. I'd like to first ask you to take a look at these documents and let me know if you have any objection to them being evidence in this hearing, and take your time. No objection? Okay.
No.
Is there anyone from the public who's going to want to be heard on this case? I don't see anybody.
So it's just the carport.
Thank you.
You good?
Yeah.
An initial inspection was conducted on September 8th of 2022. Photos depict a carport on the property. I checked Hanson and found that a permit was applied for but never issued. As of my final inspection on January 17th of 2023, the carport remains on the property without a permit.
Is there anyone else from the county who wants to testify?
Yes, sir. Land Development and Building Department.
We did have a permit applied for this after the fact carport. Back in August, there was a conversation with him that's not meeting front setbacks. It needs to. It's 11 feet from an easement, and that is not allowed. We've had no resubmittal since that time.
Can you explain what's the setback again?
The front back setback proposed is 11 feet, and it's going to need to be at least 25.
Meaning that from the county's perspective, as far as setbacks are concerned, it can't be where it's at.
Right, it can't be approved. There are places on the site plan it could be moved to meet setbacks, but where it's currently located does not meet setback requirements.
You said there was a conversation. As far as was that conversation with you or something?
No, it's actually recorded in here from one of our site review techs on August 13th. That they did speak with him at that time and he had received before denials, but August 13th was the most recent one telling him, no, you really still can't do that.
Where does it, so on Exhibit A, the photos are labeled as ATF, which I assume means after the fact, a development order. Why development order?
Development order includes permits,
Okay.
and that's what this is.
Okay. Mr. Charlton, was this your case?
No, sir.
Did you take all the photos that are in the exhibits?
I took the follow-up and photos and the corrective action follow-up and the last inspection.
Okay. And Mr. Jones, do you want to contribute anything or?
On this particular case, I don't have anything to add that Ms. Coutu hasn't already spoken
Okay.
about.
All right. Mr. Burgess, I turn to you. What's going on?
Well, I applied for a permit. The carport was put there 6 years ago, and I was just moved here, so I didn't know about permits. And they told me that the people that put the permit or the carport there were supposed to apply for the permit, which they never did, and I did not know that until just recently. So I applied. They told me I had to get an engineer to come out and do it. It would cost me $450, and they denied the blueprints onto it. So I had him come back out and do it, and he did another blueprint onto it, which cost me another $50. I've got over $500 and some invested into it, and they wouldn't accept those blueprints. They told me the reason was the carport had to sit 30 feet from the easement. The easement isn't the problem. The easement only goes 10 feet past my carport. That's as far as it goes. And the people that's got the land next door to it, he told me it doesn't bother them. They moved a double wide trailer in there. Electric company's done put a big pole in there. They put everything in there, and the carport has never bothered anybody getting in and out of there. So I didn't know why it has to be moved. It's going to cause a hardship for me. I got a bad back. I got health issues, and the reason I have it there is because it's handy for my car to get in and out of my house. And it's just going to cause a hardship if I have to move it.
Well, I mean, what the county's testified is that there is a zoning setback. Is it a zoning setback, regarding easements? I mean, normally, I just want to understand, I'm familiar with regular setback requirements. Is this a site plan review requirement?
This is a site plan review. I don't know if I'd call it a zoning setback. It's a land development code building setback requirement.
It's in the building code.
No, it's in the land development code.
It's in the land development code.
Right.
Yeah, so it has a setback requirement for easements in the LDC.
Yes.
I think I have a
Yes,
copy
you
of the
do.
LDC.
It should be building setbacks for all. I think it's the beginning of chapter 3.
Okay.
Like I said, nobody uses the easement for me to mow.
Well,
And that's it.
the problem is, it really doesn't matter whether the easement's being used or not unless it's been vacated, or you can prove that it's extinguished under, some kind of MARTA exception. But let me just look and see where that is. Yeah, I've got chapter.
I have it memorized, so apologies.
You have it pretty well memorized.
No, I really don't. All right,
Aha. Okay, so 2,300, and
should be at 50 feet from the center of right of way.
okay, right here, building setback requirement, 50 foot. So in subsection 1, it says principal uses. Well, okay, so let me start from the beginning of 2,300. A minimum setback from an abutting right-of-way shall be required for all buildings. The required minimum setback shall be measured from the center line, and it says 50 feet from a local street, et cetera. But that's for buildings. No, it's for buildings, all buildings. Then it says principal uses should be located 25 feet from any existing right-of-way line, except as provided elsewhere in the LDC. Metal or wood carports, awnings, or other open accessory structures may be permitted administratively with up to 20% reduction of the required building setback from the center line of the right-of-way. And I presume that's the section you're talking about.
It is. That's why when he's talking about 30, technically I can do 25
I
with
see.
that. But
That makes sense.
yeah.
Okay. And it's so you're telling me the right of way, or there's an easement here on the is that a right of way easement?
I got pictures here if they want to see them.
I just want to understand where it is, and I definitely will see what you have. Yeah. All right, let me just check this out, and Was this provided by Mr. Burgess? Okay. Can I ask you to first show this to Mr. Burgess, and can you confirm that you've provided this site plan to the county? Or that you recognize the document?
I didn't provide the engineer did, which is Thomas Winfrey.
Okay, but you're responsible
Yeah,
for it.
he did all the blueprints onto it.
But have you seen that document before?
Yes, I have. I
Okay.
think I got a copy of it.
I think you have too. So I just need to get that on the record. I need this to be able to understand.
So this is the easement, or no, this is the easement.
Could I see it now? Sorry.
I didn't make copies.
Do you have copies?
Yeah, I just printed that off online, on the permit, I just copied that, you can have that.
Can I rip it? All right. So this is going to be County's Exhibit C, and I'm using it to understand where the easement is, and I see that there is a 20-foot easement. So I presume the places where it would be acceptable to have it are either more north on the property or west or southwest.
Right, those are obvious options on the site plan. There may be trees or something there that's gonna dictate something different, but yeah, there are places to put it. We don't have if there's no place to put it, you get it. It doesn't work that way, but.
Mr. Burgess, do you have documents you want me to review?
You can see pictures.
Yeah, sure. I mean, could you show them to the county first and they can let me know if they have any objections?
Easement here. Easement only goes past this pole right here, as far as it goes. Nobody ever uses this. This is the guy's driveway that goes in through.
The problem, Mr. Burgess, based on what you said, is the reality is the easement does exist and the county code doesn't care whether it's used or not. If it's there, the carport that you're talking about cannot go where it is.
Yeah, but the easement only goes just 10 feet past my carport, so.
I agree.
So.
But you can't have it within 25 feet of the easement. And that's already the county giving you leeway. It's actually 30 feet. It's just them in their discretion. They can allow it to 25, and they're saying they'll work with you on that. They have to follow the law. I mean, they can't give you a special permission to do something that no one else has permission to do. Does that make sense? No one else has permission to build within 25 feet of an easement like that.
It wasn't built, it was put up. It's not even a permanent structure.
I hear you on that, but the reality is that it is subject to the building code. I'm going to accept these. Can I have these?
If I can get them back after a while, I don't know. Yeah, you can have
Well,
them.
you can't.
Okay, you can have them.
No, I mean, I'm willing to let you keep them.
No, you can have them.
Okay. I'm going to admit these as Respondent's Exhibit, Composite Exhibit A, to show that, the portion of the easement that's actually used and not used. It's got to be moved. It is in violation, Mr. Burgess.
So the only place I can move it is down, you can see the poles in my clothesline, and it's gonna have to be moved in front of the clothesline, and then I don't have any, then I can't do the clothesline. And I can't move it. I checked with somebody that could move it, but they want $300-400 to do it. I don't have the money for that. And, it's just gonna cause a real hardship with it. So if I take a pop-up tent thing, I can use that as a carport?
That I don't know. That's between you and the county.
And I'm gonna put a fence up along there where the carport is, so it doesn't, and that's, why does it matter if the carport's there or a fence is there? It's,
Well, if someone vacated the easement and got rid of the easement, you'd be fine.
well, why don't they get rid of it? Because nobody uses it. I mean, it's as far as it goes right there. And this guy here doesn't care if it's there or not, the carport.
If the people are, I don't know anything about this easement, so I don't see the document that creates it. But if the easement could be vacated or terminated or dissolved, then it sounds like the county may be willing to issue the permit. I don't know, but that might fix the issue. Alternatively, you either have to move it and get the permit for the proper location, or you need to take it down. It's one of those three options. So I am going to find that the property is in violation. What's the county's recommendation?
Citrus County Code Compliance Division respectfully requests that Special Master assess a fine of $50 per day along with the administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriately given to the severity of the violation and respondent's actions. Relative to this violation, we would also ask that Special Master additionally find that it's respondent's responsibility to contact the Code Compliance Division when this violation has abated to allow for reinspection.
So what I'm going to do is I'm going to give 120 days to abate the violation in one of the ways that I described. If the violation is not brought into compliance as ordered, a penalty of $50 per day will be imposed, and that'll constitute a lien. It may end up constituting a lien on your property. I'll incorporate the other standard order provisions, but although I'm sympathetic, the reality is it does violate the code.
So
Thank you. Sorry?
I'm looking here. All right, if I show on this where I'm gonna move it to, you can accept this and then I can apply a permit for that?
You can do that right now. I mean, that's something that you need to handle with the county, and that's exactly what you should do with the county. If they accept your location, it sounds like they'll issue the permit, and that'll be that.
Permitting today on your way out, and they'll help you with that.
All right.
All right. Thank you, sir.
Thank you.
I just wanted to let you know them pictures. I bought a throwaway camera for it, which cost me $15. I turned it into Walgreens and haven't developed. They took 5 weeks to develop those pictures. And then they charged me $18 for developing them, which I think is totally ridiculous.
I've never heard of that.
Well, that's what it was.
It's wild.
So I got $30-some developing or into these stupid pictures, which ain't gonna do me a doggone bit of good. And like I said, with I got a knee replacement may have to be done and all those things. All right, thank you.
Good luck.
Next case on the day's agenda, Charles M. Curry and Victoria K. Cages, case number 217-4698. Code Officer Brandon Norman, page 7 of your agenda. Expert on the case, Joanna Katoot.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
And your name, please?
Charles Curry.
Thank you.
Good morning.
Good morning.
Good morning, Brandon Norman, Citrus County Code Compliance Officer. This is case number 217-4698, temporary occupancy of a recreational vehicle, a violation of Citrus County Land Development Code Section 3140, temporary uses table 3-2. Addresses 13314 East Shawnee Trail, Inverness, Florida 34450. Property owner Curry Charles M. and Cages Victoria K. I have good service via certified mail return receipt. I would like to authenticate the following documents and request to be admitted into evidence. Exhibit A is photos taken during the initial inspection on October 17th, 2022, and corrective action inspection on December 27th, 2022, and photos of my final inspection on January 17th, 2023. Exhibit B will be a copy of the notice of violation, a copy of the notice of copy of the notice of hearing, and a copy of the certified mail return receipt.
Sir, what I'd like to ask you to do is to look through these documents and let me know if you have any. I'd like you to just let me know if you have any objection to them being evidence in this case, and take your time.
No.
Is there anyone from the public who's going to want to be heard on this case? Let the record reflect there's no response. Did you have any objections, sir?
Such as,
Well-
nobody's staying, well, I mean,
I'll give you a
slept in it
chance.
overnight.
I want to give you a chance to make your case. I normally let them explain to me what the case is first because I don't know. But what I want to know is, do you have any reason to believe these photos are faked
No,
or
no, no.
inauthentic? Okay. And I'm not hearing any other objection to the documents. Okay, so without objection, what's been proposed as exhibits A and B are evidence.
On October 17th, 2022, an initial inspection was conducted at the property for an RV being lived in greater than the permitted time of 14 days. The property was found to be in violation of the above ordinance. The property remained in violation of my notice of violation corrective action inspection on December 27th, 2022, as well as my pre-hearing inspection conducted January 17th, 2023. I was unable to make contact with the property owner other than the certified mail return receipt.
Okay, I'm gonna just take a moment to look through the photos in the code section. Is there anyone else from the county who wishes to testify?
This is a residential zoning, CLR MH. There is a mobile home on the site, so this is an improved lot, so the code would allow up to 2 weeks of occupancy per year.
Okay.
And he cited that it's 3140
All right,
temporary
that's what I'm
uses.
looking
Yeah.
at.
Okay.
So the county's making reference to table 3-2, temporary uses that can occur without a permit, temporary occupancy of a RV on improved property, 2 weeks per address per year. What evidence does the county have that the RV is being occupied?
Based on the way the structure is set up, I mean, there's an open pop out. There's clearly things that are surrounding the RV that's been there for an extended period of time. It doesn't look like any of that stuff's being used for storage. The county believes that someone is residing in there based off of the electrical hookup and everything else as well. So, and because we haven't had any contact with the owner, we've not been able to ask or inspect or anything like that.
Well, Mr. Curry, you've heard the county's case. What's going on?
It's what it is. I'm renovating it inside. That's why electric's out there for the Sawzall and everything. I'm not saying I haven't slept in there overnight once or twice when, I'm working on it. I work on it mostly at night. But as far as nobody's living in it, the stuff that's outside was in it, and I moved it outside and I had no other place to put it right at the moment, so. But, a lot of this comes from disgruntled neighbors.
Clearly, there was a complaint.
Yeah,
what was
this is going on and on. I'm thinking about filing harassment charges against them soon because they've had everybody and their brother out there, and it's like everything has been resolved and there's been no issue with the departments that come out. They found it unfounded, so it's just
the departments? A department has come out before?
not yours.
No, I'm not a part of any department.
Right,
but
well,
what department has
Health
come out?
department come out because they said this was wrong and that was wrong, and then they come out and inspected. There was.
Well, actually, can you tell me about that? I mean, what did they say was wrong?
They said I had sewer all over my backyard.
That you had a sewer?
Mm-hmm.
Or that you were discharging?
No, I had sewer all over the backyard. It was leaking through the ground, and they come out and they inspected it. They seen it wasn't. There's another. It's just numerous. Have the sheriffs come out for this or that.
Are you using the bathroom in this RV at
No.
all? Okay.
No, I have. That's my home. Why would I?
Is there any evidence from the county that the RV has discharged any? I don't know what the right word would be, but waste.
Even though there hasn't been on our end any evidence that there is a disposal of waste from the RV, we still do believe that the RV is being lived in based off of the complaint that I initially received from the complainant, stating that the house is currently being rented out and the property owner is now living in that RV while the house is being rented out. That was my initial complaint. That's why I went out there.
Okay.
Um,
Not renting the house.
well, Mr. Curry, is the house being rented?
No.
Have there been any other occupants besides yourself of either the house or the RV in the past 3 months, like on a permanent basis?
Yeah, my ex-girlfriend stays there with her disabled son, and she's trying to get moved, and it's hard for her with that. So in the meantime, she's still there. But yeah, that's it. I mean, it's just, like I said, it's just constant. Some like the next is gonna be that tree, which I'm trying to get removed, but that fell down, so I couldn't.
Does the county have any other code enforcement cases on the property?
There is one more active code enforcement case.
I had a feeling there was.
That one's being handled by Officer Nocella.
Okay. I mean, it's not before me today.
No, yeah. No. But it is currently active, yes, sir.
Is there any way I can know of this or what the complaint is?
Oh, is there? Well, so I'll just tell you what I see.
I know
I'm not going to put the
tell you
burden
what it
on them to
is.
say anything, but it looks like there's potential junkyard conditions on the property. So you probably will want to fix.
It's already been found guilty, so it's,
Oh, did I already preside over it?
yes, sir.
Oh,
You did, I don't know if you showed up. I don't remember you appearing
sir.
here.
I
Okay.
did paperwork on it, I guess.
Okay.
That's in the process of being straightened out now, so.
Well, here's the deal. I just don't find enough evidence to prove the case, and so I'm not going to find in the county's favor. That's it.
Okay, thank you.
Thank you.
May I speak?
Outside, after the hearing.
Was there anybody from the public on that one?
Was there anyone? I asked if there was anyone from the public. I didn't see anybody. So.
Next two cases on the agenda, Crystal Stiegler, case numbers 2177612 and 2177614, Officer J.C. Charlton, pages 22 and 23 of your agenda. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
And your name, please?
Christelle Stiegler-Dara.
Thank you.
Good morning.
Good morning.
Good morning. J.C. Charlton, Citrus County Code Compliance Officer. Case numbers 2177612 and 2177614. Accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A, and unlicensed and inoperable vehicle, a violation of Chapter 20, Article 4, Section 20-41 of the Citrus County Code of Ordinances. The address is 6881 West Arlington Place, Homosassa, Florida. Property owner is Christelle Stiegler. Good service via posting the property and at the Lecanto Government Building. I would like to authenticate the following documents and request to be admitted into evidence. Exhibit A, photos taken during my initial inspection on November 16th of 2022, corrective action inspection on December 27th of 2022, and final inspection on January 17th, 2023. Exhibit B, the notice of violation, notice of hearings, and photos of the posted property and a copy of the posting affidavit I completed.
Ma'am, I'd like to ask you to take a look at these documents and let me know if you have any objection to them being evidence in this hearing.
Yes.
All right, take your time. Are you presenting both cases together?
Yes, sir.
Okay.
So the unlicensed vehicles are going to be these two, correct?
Yes, yes.
Okay. So what point, if it's not seen by the public road, does it become a violation of my Fourth Amendment, the expectation of?
We can talk about that, but the first step is figuring out whether you have objection to these. Oh, you're saying that you have a Fourth Amendment objection to the photos.
Oh, yeah, yes, because if you can't, for once, the junk, if you can't see it from the roadway and I have the reasonable expectation of privacy in my backyard, why would that be a evidence of?
You don't. Someone could put a drone up in the air, take photos of anything in your backyard, and it could go from anywhere. But the Fourth Amendment also generally otherwise protects against unreasonable searches and seizures which aren't present here. So just as far as the photos are concerned,
Yes, I
no, I just, if you have a constitutional objection, I'm perfectly willing to hear it. I hear you making a Fourth Amendment objection. I'm thinking about it. But that normally only applies when if someone has gone into your house and sees something without a warrant or something like that. How were the photos taken, Mr. Charlton?
I've received access from a neighboring property, and during a follow-up inspection, I met with the property owner.
It's not a violation of the Constitution.
here you go.
But, I mean, I will hear whatever you have to say in your defense, I want to hear.
Yes.
But for the moment, what I'm most curious about is do you have any other objections to these documents being evidence in the hearing?
No, sir. If
Right.
it's if the junk is just the axle in the corner of the back property. And well, I have questions about.
And I want
Further-
to just
we'll
make
go
sure they're
further
able
on.
to hear. I've never had a Fourth Amendment objection before, which I appreciate. I think that's good. Is there anyone from the public who's going to want to be heard on these cases? Okay, see no response. Without any other objection, Exhibits A and B will be evidence. So what's going on?
An initial inspection was conducted on November 16th of 2022. I observed a discarded frame or car axle on the back of the home. There was also an unlicensed inoperable RV as well as an inoperable SUV on the property. I've had contact with the property owner and explained both violations. As of my final inspection on January 17th, 2023, the items remain on the property.
And what is the, okay, so I just want to, have the tires ever changed location? Or?
No, and it appears like it's just a discarded car axle.
Okay,
So it's
I
still,
see,
you know.
I see. So the photos are just taken from a different angle?
Yes, sir.
I see. And what if I want to hear from Stiegler, but what would you characterize the substance of your conversations with the owner to be like?
She was open to listen to, the violations, but there hasn't been any improvement or any way, shape, or form, any communication stating that they will abate the violation.
Okay.
So.
So what is your perspective on what's happening?
Well, I work in a school system and I work 8 a.m. to 6 p.m. because I do bus runs. So typically everything is closed by the time I get out of school, and we had a recent death in the family. So I've been spending a lot of my weekends at my grandmother's house. The axles are recent actually because we dismantled a truck for parts and got rid of everything else for it. Both vehicles are operable. The RV just has flat tires, but its engine is everything runs.
Okay.
And, I heard in one of the prior cases about RV as being storage. Was that what I believe Curry's?
The last case?
I was gonna ask about that. 'Cause
Well, the last case wasn't really about storage. It was about whether or not he was occupying it for 2 weeks, more than 2 weeks in a year. And, whether he is or he isn't, I had an evidentiary issue with it. But the important part for your purposes I want to address the RV first.
Yes, sir.
Is that we have to turn to the county code to see, do they have a definition of this? And I believe they do. So basically, here's where they talk about unserviceable and inoperable vehicles. It says, it shall mean vehicles which have any of the wheels or tires dismantled or uninflated. So they've thought about what you're saying already, and the county's already thought about it, and that's why they've continued the case on the RV. So the other one, what's the other vehicle on the property? That's
It's Not mine. No, it's not mine. It's my boyfriend works for a stucco company, and he worked on a house, and the guy who owns it died, and he got it as a tip. It's operable. It has the key and everything. We just don't have it registered. I don't even think that's not. The tires are inflated, and it's been moved. I mean, not moved since this.
Right. So let's.
So I wouldn't even know. And in the process, I have also purchased temporary shelters with all four walls on the side, like, and a roof. I have them, but I didn't realize it was just going to be the tarps. So I have a 40 by 20. I just have to get the frame for it now. That was going to completely enclose that RV and other.
Well, here's the issue on the other vehicle. Section 20-41 states, it shall be a violation of this article for any person to keep, dump, store, place, or deposit abandoned, unlicensed, inoperable, et cetera, et cetera, et cetera, or vehicles without a valid registration or tag.
Right, I understand that it does.
Well, you indicated that they were both operable, so I just wanted to for your benefit, walk through the reason why I am going to find that there's a violation.
Yes, sir.
How much time do you need on each of these cases to fix them?
So the RV will be fixed as long as I blow up the tires. And
As far as I know.
Correct. And I need to get.
If it's registered.
Yeah, assuming it's registered and
They didn't have a valid
I
tag.
have everything that I can register.
there's no
it
tag
with.
on it?
The tag was expired.
Okay.
I have everything that I can register it with.
Okay. Well, so what I'm gonna find is that just the violations from the code section have to be abated. I'm not gonna make a finding that as long as you inflate the tire.
No,
I know we're just talking. So what I want to know is how much time do you need to fix everything you need to do with the vehicles and also get rid of the offending axle material auto parts?
Well, considering that I work and may I have the 90 days?
What's the county's recommendation?
Citrus County Code Compliance Division respectfully requests Special Master assess a fine of $100 per day along with for both violations, along with the administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriately given to the severity of the violation and respondent's actions relative to this violation. We'd also ask the Special Master additionally find that it is respondent's responsibility to contact the Code Compliance Division when this violation has abated to allow for reinspection.
What I'm going to do is I'm going to find that the property is in violation, but I'll give two different. So on case number 217-7612, which is the auto part case, we'll grant 60 days from today to abate the violation. If the violation is not brought into compliance as ordered, a penalty of $100 will be imposed. But in case number 217-7614, I'll grant 90 days from today to abate the violation. And if the violation is not brought into compliance as ordered, a penalty of $50 per day will be imposed. I make that finding to be consistent with the other cases we have regarding the vehicles. I do think the axle issue could be resolved a lot faster than potentially the vehicle ones. So, and otherwise I incorporate the other standard order provisions. That's it.
Yes, sir.
Thank you.
May I ask a question? Does that the one for the RV, does it include that second car in the verbiage?
It does.
Oh, okay. Does it? So this is a neighbor issue, and I'm sure most of these cases
Most code enforcement
are,
cases are neighbor issues.
and I could understand that. So, I don't know.
I can't really comment on neighbor
That's why I'm
issues.
we're trying to.
And it doesn't sound like anyone came to talk, or at least made their feelings known to me, but it's not going to be a part of this hearing.
Yes, sir.
All
Thank
right,
you.
Good luck.
I appreciate it.
Next case on the day's agenda, Charles R. and Gail E. Stahl. Case number 217-5984, Code Officer Brandon Norman. Page 21 of your agenda. Expert on the case, Carl Jones, Building Director.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name for the record.
Charles R. Stahl.
Thank you, sir.
Thank you.
Good morning, Brandon Norman, Citrus County Code Compliance Officer. This is case number 217-5984, construction or modification of a structure without required permits, a violation of Chapter 18, Article 1, Section 18-A, subsection A of the Citrus County Code of Ordinances. The address is 5770 South Cherokee Terrace, Inverness, Florida 34452. Property owner Stahl Charles R. and Stahl Gail E. I have good service via certified mail return receipt. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during initial inspection on November 4th, 2022. Photos taken at my compliance inspection on December 27th, 2022. And photos taken at my final inspection on January 17th, 2023. Exhibit B will be a copy of the notice of violation, a copy of the notice of hearing, and a copy of the certified mail return receipt.
Okay. Sir, I'd like to ask you to take a look at these documents and let me know if you have any objections to them being evidence in this hearing.
I've got that, buddy. I don't accept some of these.
And what do you mean by you don't accept?
I don't see where it comes into play where I'm in code violation on a roof where they've got inside a bathroom. I don't understand that.
Okay. So it's a relevance. I'll take that as a relevance objection. On which pages are you making that objection?
The first one, the third one,
I do have a statement,
It's
whenever you're ready.
well, yeah. Let's wait for this.
Yeah.
number 8,
Okay.
number 12, rest I understand.
Okay. Then we'll take it subject to these objections for now. I'll rule on them later. What's your statement, Mr. Norman? It's what?
Everything that he's
Oh, no, I mean, I won't rule on it until I hear what the county has to say. All right. Thank you. So in order to gauge whether or not something is relevant, or that would be a valid objection for these purposes, this kind of a case, I need to hear what the county is presenting.
Yes, sir. On November 4th, 2022, an initial inspection was conducted of the property for modifications to a barn to convert it to an apartment, as well as the installation of a new roof to the barn. I was invited into the space by the tenant at the time and photographed the inside as well as parts of the roof. Research was conducted in Hanson and was determined that no permit had been applied for any of the modifications. I was able to contact the property owners. They stated they were unaware that they needed the permits. I gave them instructions on how to obtain the after-the-fact permits. On December 27th, 2022, I conducted a compliance inspection. I was unable to view the inside of the property, but I was still able to view the outside. And I found that there was no change. I spoke with the property owners again and informed them again on the steps they needed to take. And then at my compliance inspection yesterday, no permits have been applied for.
Is there anyone else from the county who wishes to testify in this case?
I can just say that I've looked over the pictures, and any renovation work that would have been done to convert a barn to a residence would require a permit, to include plumbing, lavatories, electrical, the restructuring of the roof over top of it, all of that.
And
would
is it the
require permits.
county's, is the county aware of whether or not there was a bathroom there before?
We are not.
In other words, you're not aware one way or the other? Or are you saying there was no bathroom?
We don't have a history on that building.
There's no history on the, so is there any record of the barn being built?
Not
Or a permit?
Nothing I can find in the research, no, sir.
All right, so let me,
I have something, sir.
well, yeah, and I want to hear, I always want to understand what they're saying before I turn to you.
I understand.
I'm not sure.
Excuse me. Pardon me.
I'm almost there.
Based on my research, sir, the only permit that I've ever seen that's been issued for the property is for a new roof for the mobile home. That's the
Okay.
only thing I was able to find.
All right, let me look, so. And what I'm doing is I'm matching up page numbers where objections have been made.
Just so you know, sir, the last two photos are just overall pictures of the property, just because the tenant no longer is there, so I wasn't able to access the interior to view.
Are all the photos that have been provided of either the exterior or the interior of the barn or former barn structure? Is that yes? They are?
Yes, yes.
Okay.
Every photo that's there present is of the barn structure.
Does that explain why they have photos of these other, of the bathroom, for example? Because what it seems to me that their case is that you've converted a barn that didn't have, or at least has never had permits for the bathrooms that are in the photos and the sinks and stuff like that, and that they need a permit. It sounds like that's what their case is. So that's why those photos would be relevant. Does that make sense or no?
It does, but that building's been there from day one.
Okay.
Okay, I didn't put the barn up.
Okay.
I bought it, it was there. The bathroom, the shower, The other part there with the kitchen-like kind of deal?
As long as you've been there, those have been there.
Yes, sir.
Okay. I'd love to hear your side of the case.
Well, I do have this right here that shows the original trailer and also the barn. It wasn't initially turned into an apartment. The man never paid rent, one, okay? He was a friend. I did some work on the roof, basically. I was upgrading it because it was leaking, okay? I should have got a permit, simple as that. Just grown. I have applied for a permit. Unfortunately, it was a wrong permit at this point in time.
What permit did you apply for?
It wasn't after the fact, okay? It was just a permit,
I
and
see.
I didn't realize that,
Okay.
to be honest with you.
Did the county tell you, or has it been rejected?
No. They accepted it, but I haven't been given anything.
Okay.
Do you mind if I take a look at
Oh,
this?
certainly.
Let me see what you got. Okay, one of my permit texts, this is a notice of commencement.
It looked like a notice of commencement, yeah.
Permit application, and there is a permit application number on the top.
Okay.
Looks like number 307 of 2023, so it was probably applied for this week.
Okay.
That's
Yeah.
my estimation. I'll have to look into this recent application to see what.
And
what's in
it sounds like it was an application for a roof or
It says,
a permit for a roof.
general description of improvement is upgrade.
Okay.
And with that single word description, this would not be accepted.
Okay.
It's too vague.
Has that notice of commencement been recorded in the public records?
Yes, sir.
Okay.
I didn't realize that it would have to be that specific, but it's mainly the roof. We have done no interior thing to it, to be honest with you.
Well, here's the issue. Even if you're right that everything, was there before when you came into possession of the property, if something hasn't been permitted and it has to be permitted, it still has to get an after-the-fact permit, whether you bought the property that way or not. Does that make sense?
It's been there since 1990. Actually, we moved in 79. It's been there since then.
So since 1979, the barn?
Yes, sir. Yes, sir.
Okay.
Also, the lady at the window wrote this and asked me, and I told her it was an upgrade on the roof.
Okay.
She didn't put it down as that, it's just an upgrade.
I don't know if it's her responsibility to do that.
I understand that.
Yeah.
Then I should have had the paper to fill it out myself then.
Okay. The issue that it's conceded that there's a roof issue, right? Okay, so that's the easy part. I'm going to overrule the objection to the pages because I understand why the county wants to talk about these things, and therefore exhibits A and B are admitted as evidence over the objection, which is noted for the record. Pages 1, 3, 8, 12. And the issue then remains as to whether or not the structure that is here was built prior to a requirement for such a permit. And I don't know if the county is prepared to offer either any evidence or legal argument as to, in other words, the undisputed evidence so far is that it was this way, except for the roof, as of 1979. I have some understanding of when the Florida Building Code became a statewide requirement, which was decades before that. But nonetheless, I just don't know if this applies or not. Can the county help me? In other words, Mr. Jones, what I'm saying is if something was built in 1903, for example, those things get grandfathered in under permitting requirements. And I'm concerned that I don't have, under most permitting requirements, and I'm concerned that I don't have enough evidence to require a permit for, everything else that the county's talking about besides the roof.
Okay. I may not have my dates exact, and I'm going to throw this disclaimer out there.
Yeah.
But the Citrus County Building Division was established somewhere in the vicinity of 1974.
Mhm.
And we recognize that there are pre-existing buildings that were prior to the adoption of the code
Correct.
that was in place when the building department was established.
Right.
There was a memorandum put out by the growth management director. His name was Vince Cotero, and he put it out somewhere around 2010. And in that memo, it said, any buildings that we can verify were established and in place prior to 1994, we will accept them as existing established buildings.
Really?
And take no code action on
That's
them.
that was the county's
That was
position?
Mr. Cotero's contention at the time, and we have held to that ruling by that growth management director. So our target date is 1994.
Wow.
It also coincides with the adoption of the Florida Building Code proper. That first version was the 1994 edition. If it would be helpful, we could do the research on this building and postpone this till the next meeting for us to do that research and find out exactly what evidence we do have about this building and its status.
I
If
have
that-
some right here in my hand,
Well,
August 1985.
we're going to talk about it. But I do want to ask the county to possibly advise me on that position, because I've also not known that, though it makes sense. I'd love to know more about that, just in general. What do you have? And can you show it to the county first?
Oh, most definitely.
What I just want to know is if the county has any objection to it being evidence in this hearing.
This appears to be a sealed survey by, the surveyor was Willard R. Bowski. The date of the survey is August 16th, 1985.
Right. A survey may not be relevant for saying what's on the inside, but it may be relevant for showing that the structure predates so I
It
just,
shows an existing mobile home and an existing frame shed. Don't know if it's the shed that's in reference here. Can you look at the relationship between those two buildings and see if you would think
I think it's relevant, so I just want to know if the county has any objections to it being evidence in this
No,
hearing.
we don't, but I will clearly say that the survey indicates it as being a frame shed,
Right.
not a residence or
I understand.
habitable building.
I
No,
understand.
sir, it wasn't. You're right.
Okay. Well, okay, so I need to see this. Are you willing to give me this document?
Oh, most
All right.
definitely. I have another.
So without objection, unless Ms. Antrim wants to review it. Okay. Sir, would you mind giving that to Ms. Antrim?
Not a problem.
Thank you.
Okay.
Now, do you own two lots?
No, my
Okay.
son owns the one next to me.
All right, so
That's
all
what-
of this
'cause
is
they
on one
started
lot.
with Christopher, and then they changed it because they realized it was the next lot.
All right.
Okay. Without objection, this is going to become Respondent's Exhibit A. I'm going to take a brief look at it, and then we're going to talk about what you just said, Mr. Stahl. I see. I see. Okay. All right, so Mr. Stahl, you said you agreed with what Mr. Jones said, how he noted that it's essentially a frame structure. Has it been changed since then?
No, sir. It was a barn from day one, but it did have a laboratory in it.
A laboratory?
Well, it's got a bathroom in it.
Oh, a lavatory. I'm sorry, I thought you
Okay.
said laboratory.
No, sir. No, I don't. I'm not. No.
Well, you never know.
I know.
So you're saying it's still a frame shed today?
It is a barn.
It's a frame barn?
Yes, sir. 2-story.
There is additional sections to the barn that I didn't have access to because it's separate from that living space that's right there.
No, you were in it if you were in the bathroom. You were in the barn.
What part did you not have access to?
There appears to be like a garage type area.
Okay.
You can view it that it's open on the last photo on
Okay.
the 17th.
Why didn't you have access to it?
The way the tenant explained to me that that was the only assigned space that where he was
I see.
at. So I only had purview to that.
They never asked me.
All right. Sounds like they were trying to do. Oh, I see the frame.
We can continue this and research the construction history on the building, however, it still doesn't make up for the requirement of a permit to put a
Right.
roof repair or put a new roof on.
Right. I'm thinking about it. I want to make sure that I'm fair to both sides, and I'm thinking about what
Can I add
happens.
something else, sir?
Yeah.
I've been paying taxes on this after it was built. They came out and assessed it
After what was built?
after the garage was built
When was the garage built?
in the 90s, 1990.
So the garage is in addition to the barn?
Pardon me?
The garage is in addition to the barn? I wasn't aware of that. I just thought it was one whole structure.
And
'Cause that's
so,
what it appears
but
to be.
that still would predate 1994. So what I will do is, all right. So Mr. Stahl, I will find that there's a violation as far as the roof.
Understand.
Okay. But I'm not going to issue an order yet. I'm going to continue the hearing to next month so that we can resolve and figure out, you know, the job will be the county's. The county needs to provide some kind of evidence that, based on the memorandum and I think the policy of the county, either there's a violation, the county has proof that these things were built 1994, post 1994, or there isn't, and that part should not be brought up at the next hearing. If there isn't, then all we'll deal is I'll give a time to fix the roof. Okay?
Understood.
So we'll continue this to next month. I apologize. I know it's an
No, sir,
inconvenience,
that's fine. Excuse me.
but we want to get it right.
No, sir, and I appreciate that very much, to be honest with you.
They want to do what's right too. I've heard a lot of this is interesting. So, thank you.
It's interesting for me too. Is there a date when I should be
You'll
here?
get a letter.
Letter? Another
February
certified?
15th.
It'll be the third Wednesday. No, the February 15th.
Yes.
Yeah, you're right. Third Wednesday of February. Okay.
Okay, and there will be a time, same time, 9 o'clock?
Yes, sir.
Thank
Thank
you,
you.
sir.
Yeah. Yeah.
Next case on the day's agenda, Gene Lubowicki, hope I'm pronouncing that right. Case number 217-8553, Code Officer Brandon Norman, page 17 of your agenda.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
Your name, please, sir?
John Wyatt.
John,
Wyatt.
thank you, W-Y-A-T-T?
Yes, ma'am.
Sir, are you a tenant on the property?
Yes, I am.
Thank you, sir.
Brandon Norman, Citrus County Code Compliance Officer. This is case number 217-8553, accumulation of junk and debris, a violation of Chapter 20's, Article 3, Section 2031, subsection A of the Citrus County Code of Ordinances. This is a repeat violation initially observed on December 19th, 2022. The address is 7419 West Chassahowitzka Street, Homosassa, Florida, 34448. Property owner, Lubowicki, Gene. I have good service via certified mail return receipt in addition to posting at the property and the Lecanto government building. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during an initial inspection on December 19th, 2022. Photos taken at my final inspection on January 17th, 2023. Exhibit B will be a copy of the notice of hearing for repeat violation and a copy of the certified mail return receipt and photos of the posted NOH RV at the property. Exhibit C will be findings of facts and order acknowledging compliance from previous case number 2143749. And that's all I have.
Okay. Sir, I'd like to ask you to take a look at these documents and let me know if you have any objection to them being evidence in this hearing, and take your time.
Oh, she's. Okay. Fine.
No objection? Okay. Is there anyone from the public who's going to want to be heard on this case? I see and hear none.
So, oh, he abated late, or he abated on time?
Without objection, what's been proposed as exhibits A through C are evidence. Thank you.
On December 19th, 2022, an initial inspection was conducted of the property for junk and debris. The property was found to be in violation of the above ordinance. The property remained in violation when I posted the property on December 29th, 2022, as well as my pre-hearing inspection conducted January 17th, 2023. I have had no contact with the property owner, other than the certified mail return receipt.
Okay. And you've had no contact with the tenant?
No, sir.
Okay. sir? What's going on?
My son was staying there while I was in the hospital again. They were threatening to take my leg. They've already took one, but when I got out, I cleaned it as quick as I could, and I kicked him, evicted him out of the house.
Okay. All right, let me take a look here. It does look like there's been a lot of improvement in the past month. Is that accurate, Mr. Norman?
I would say it's accurate, but there's still some areas of concern. I did observe on the 17th when I did my pre-hearing inspection, one of the gates were ajar. I have concerns for the backyard as well. I just couldn't view those at the time when I did my initial inspection.
And so, Mr. White, it appears that you have appeared before me before. It was about 1.5 years ago on the same thing. I'm just reading the prior case. Previously, I had given 30 days from the date of the order, and then $50 per day, and then it was fixed. So what? How much time do you need to fix it this time?
What and all has to be done?
I'm sorry?
What and all needs to be done?
Needs to be cleaned up. So the case is
Mainly all I got the boat and my trailer's there now.
Well, so what appears in the photos is that this is a junkyard and debris case, and there are a lot of miscellaneous items strewn across. They're kind of pushed to the side of the front yard.
That's all taken care of now.
Okay, well that's good, but that has to be fixed. And also, what it does appear in the photos and what Mr. Norman's testified to is it appears there's a lot of junk in the backyard too.
There's some in the backyard. I'm cleaning it up.
Okay, so my question is, how much time do you need to fix all that?
Got 90 days.
Okay. Now, because this is
I'm working by myself.
Right.
I kicked my son out.
Right. Because this is a repeat violation, I believe the county will ask, and I'll be required to assess a fine from the date that it became a repeat violation until today. Does that make sense?
I guess so.
Okay. The reason is that when there's a repeat violation, you want to deter future violations. And so if it happens again, then the fine will begin instantly.
It was cleaned up before I went in the hospital. And my son just drug in. Now I kicked him out and threw whatever else I could out.
Right.
Now I gotta go clean the backyard.
What I have discretion to do is the amount of time I give you to fix it, right? But I don't have discretion on finding that there's no violation based on someone else doing it. I believe, I mean, it sounds like very credible testimony as to the reason why, but nonetheless it occurred. What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $150 per day along with the administrative cost to begin on the date of posting on the property, which was December 29th, 2022, and continue until January 17th, 2023. This would be a total of 19 days at a rate of $150 per day, totaling $2,850. We also ask that the special master impose a fine of $150 per day from this day forward until the violation is abated. This amount was selected based on the actions of the property owners once they are advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask the special master additionally find it its respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
Are we still requesting $150 a day under the circumstances that he's been hospitalized? during that period?
We can-
It's irrelevant. I'm
he's-
not
but
gonna
he's-
do 150.
He's
so.
he's the tenant. Though, but-
I know. Well, no, I mean that.
Yeah.
Look, the tenant's the responsible one.
Yeah.
But what were you in the hospital for?
They're threatening to take my second leg off. They've got the right one already.
And may I ask when you lost the first one?
About 2 years ago.
2 years ago. The issue on a repeat violation is I really don't. If I find a repeat, or I have to find a repeat violation. The issue is that I can't really give you a time of grace to comply. It's got to get fixed. And it had to be fixed as of the date that Mr. Norman's telling me. And your neighbors and the public expect the law to be followed so that these properties are cleaned up regardless of our circumstances. What I can do is I have some discretion on the fine. I mean, Mr. Norman has, I mean, you haven't had contact with him at all, right?
Not at all, no.
Okay.
And from my understanding, we're attempting to hold the property owner accountable for these actions.
Yeah.
Because they are overall responsible of their tenants and their property as well. So.
Well, the way the owner, it sounds like, would hold them responsible is by evicting them. So I don't know if that's going to do the job for Mr. Wyatt, but, you know, the public interest has to be served. All right, so what I'm going to do is I will find a repeat violation occurred from December. I'll adopt the county's proposed findings of fact. And what I will do is assess a fine from December 29th to January 17th of $50 per day. And from today's date going forward, there will be a fine of $100 per day that it is not brought into compliance. The fine will be recorded and will constitute a lien on the property owner's account, and I otherwise incorporate all standard order provisions.
Thank you, sir.
Thank you. Good luck.
Next case on today's agenda, Vicky L. Hart, case number 217-7130, Code Officer J.C. Charlton, page 13 of your agenda.
Hi.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
And your name, please?
Vicky Hart.
Thank you.
Thank you.
Good morning.
Good morning.
J.C. Charlton, Citrus County Code Compliance Officer, case number 217-7130, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address is 5580 South Woodside Terrace, Homosassa, Florida. Property owner Vicky L. Hart. I would like to authenticate the following documents and request it be admitted into evidence. Exhibit A, photos I took during an initial inspection on November 16th, 2022. A corrective action inspection on December 7th, a follow-up inspection on January 5th of 2023, and my final inspection on January 17th, 2023. Exhibit B, copy of the notice of violation, copy of the notice of hearing, and a copy of the signed certified mail return receipt.
Ma'am, I'd like to ask you to take a look through these documents. Yep, and let me know if you have any objection to them being evidence.
Doesn't surprise me. Yeah, that they took that in yesterday. Yes, I agree with that.
Thank you. Fire about to go out of control.
Thank you. Without objection, what's been proposed as Exhibits A and B are evidence.
An inspection was conducted on November 16th of 2022. I observed garbage bags, household garbage overflowing from the trash cans, discarded auto parts, furniture in a burn pit, and other items of debris on the property. I've had contact with the property owner and explained the violation. As of my final inspection on January 17th, 2023, there has been good progress made. However, the property remains in violation with a pile of debris and tires on the property.
That's actually gone. They took that yesterday.
What did they take yesterday?
Lawnmowers, an old washer, tires are gone, glass is gone, trash is gone. It's my daughter's house. And
Okay. I also have photos from yesterday.
oh, did okay.
You know, and I guess based on the photos, I do see improvement. I don't see full compliance. I'm assuming that not much time is needed. I mean, honestly, I see a lot of improvement.
Oh, yeah.
A huge amount of improvement. How much time do you think is needed to get this thing totally to the finish line?
Not more than 30 days.
Okay. What's the county's recommendation?
Citrus County Code Compliance Division respectfully requests a special master assess a fine of $50 per day along with administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and respondents' actions relative to this violation. We would also ask the special master additionally find that it is respondents' responsibility to contact the Code Compliance Division when this violation has abated.
This is around the time when my attention starts flagging a little bit without caffeine. So I don't know if I've asked for public comment yet. Is there anyone from the public who wishes to be heard? I may have. I just don't remember. All right. I don't see anyone. I'll adopt the county's proposed findings of fact. I'll grant 30 days from today to abate the violation. If the violation is not brought into compliance as ordered, a penalty of $50 per day will be imposed. And that would constitute a lien on the real or personal property of Vicky Hart. I'll incorporate other standard order provisions, but that's it.
So that when they get it cleaned up, I just give you a call?
Yes, ma'am.
Okay. I have a question for all of you.
Okay.
Would the housing, let me see, the housing market right now and people not finding a place to live, there's not a special permit you could apply for like temporary housing in an RV?
I don't. That is
2 weeks
that's
ago-
beyond the scope of the hearing or my
Okay.
ability to answer. And in fact, I have to ask you to either consult with the county or
Okay.
hire a lawyer.
Well, I heard the other
I did.
cases, that's why I was asking.
No, it's a fair question. It's a lot of people have good questions. There's a lot of code sections here to
I
go
mean,
through.
it's your own property. Why would you not be able to live in an
Well,
RV?
you know, they don't teach land development code stuff in elementary school and never have, but maybe they should. So
Yeah.
that's all I got.
There we go.
Yep.
Anything else I need to do?
Nothing. I will issue an order, but
Okay.
I encourage you to keep in touch with the county.
Oh, definitely.
All right.
Thank you.
Thanks.
Next case on the agenda, Vanessa Leo Grand, case number 2177481. J.C. Charlton is code officer, expert on the case, Joanna Katu, page 16 of your agenda.
J.C. Charlton, Citrus County Code Compliance Officer, case number 2177481, special requirements for all accessory structures, a violation of Citrus County Land Development Code 3102A. The address is 6747 West Pershing Drive, Homosassa, Florida. Property owner Vanessa Leogrand. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during the initial inspection on December 1st, 2022, and corrective action inspection on December 27th of 2022, and photos of my final inspection January 17th, 2023. Exhibit B, a copy of the notice of violation, notice of hearing, photos of the posted property, and a copy of the posting affidavit I completed.
Is there anyone from the public who's going to want to be heard on this case? Let the record reflect there's no response. I mean, they don't teach you. I don't think it's too early to learn about mortgages, notes. It's amazing what you can graduate from high school without knowing, and what you can graduate with knowing. I mean, I had a biology class. They taught me about the stomata on leaves. When have I ever used that? Boy, I could have learned more about mortgages.
My kids couldn't write a check when they graduated. They didn't know how to do it. I'm like,
Well, they don't have a class on that either, though.
We did,
You did?
I did too.
and it was, I don't know if it was part of our social studies or what, but we
I
had
don't
to
remember.
learn.
Yeah,
That's
but
probably
I
what
did.
home
We had to
ec
learn
was
how
back
to
in the
do
day.
stock market, take care of a checking account, all
Yeah.
that stuff.
We had a woodworking class no one took, but probably should have, and that's the state of our system. But everyone is expected to know this. I mean, you're charged, you got to follow it, and so, okay. Without objection, their evidence.
An inspection was conducted on December 1st, 2022. Photos depict the camper on the vacant property. I've had no contact with the property owner as of my final inspection on January 17th of 2023. The camper remains on the vacant property.
Is there a truck there too?
The truck was there, I believe, doing a corrective action inspection or posting.
You had no contact with anyone though?
No contact, but
Okay.
the camper is from another property that we've had a case on. They just
Wow.
moved it.
All right. Is there any other testimony from the county?
It's medium density residential with mobile homes allowed. The owner does have an abutting residence that could have the trailer accommodated there, but it's on the vacant lot.
Okay. What's the county's recommendation?
Citrus County Code Compliance Division respectfully requests a special master assess a fine of $100 per day along with the administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriately given to the severity of the violation and respondents' actions relative to this violation. We would also ask the special master additionally find that it's respondent's responsibility to contact the Code Compliance Division when this violation has abated.
Okay. I adopt the county's proposed findings of fact. Properties in violation will grant 30 days to abate the violation. If the violation is not brought into compliance as ordered, a penalty of $100 per day.
Thank you.
Thanks.
Next case on today's agenda, Peggy J. Kinney, case number 217-6935, Code Officer Brandon Norman. Page 15 of your agenda. Expert on the case, Carl Jones.
Good morning, Brendan Norman, Citrus County Code Compliance Officer. This is case number 217-6935, construction or modification of a structure without required permits, a violation of Chapter 18, Article 1, Section 18-8, subsection A of the Citrus County Code of Ordinances. The address is 5712 East Arbor Street, Inverness, Florida 34452. Property owner Kinney Peggy J. I have good service via posting at the property in Lecanto Government Building. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A is photos taken during an initial inspection on November 18th, 2022. Photos taken at my compliance inspection on December 27th, 2022. And photos taken at my final inspection on January 17th, 2023. Exhibit B will be a copy of the violation, a copy of the notice of hearing, and a copy of the posting affidavit, as well as the photos posted for the notice of hearing.
Is there anyone from the public who wants to be heard on this case? The record reflect there's no response. Thank you. The objection, what's been proposed as exhibits A and B are evidence.
On November 18th, 2022, an initial inspection was conducted of the property for a shed that was erected without a permit. Research was conducted in Hanson and was determined that no permit had been applied for. I was able to contact the property owner. He stated he was unaware that he needed the permits and stated he would obtain the after-the-fact permit. On December 27th, 2022, I conducted a compliance inspection and found no change. I was contacted by a third-party permitting company on behalf of the property owner who stated they were handling the permitting issue and asked what permits the property needed to come into compliance, to which I advised them about the shed. No permits have been issued as of today.
Is there anyone else from the county who wishes to testify?
No, I don't have anything to add to this.
Okay.
We all know sheds require permits.
Okay. You shouldn't assume I know anything. I mean, that's a very dangerous assumption. But what's the county's recommendation?
Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day along with the administrative cost to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask the special master additionally find that it is the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
Does the county have any health, sanitary concerns?
None at all. It's just a utility
Besides
shed, that's all.
the fact that it's always a potential issue for the public, of course, to not have a permitted and inspected structure. All right, I adopt the county's proposed findings of fact. They're granted 90 days from today to abate the violation. If the violation is not brought into compliance as ordered, a penalty of $50 per day will be imposed, and I incorporate all the other standard provisions.
Thank you, sir.
Thanks.
Next case on the day's agenda, Jonathan R. Gleason, case number 217-4599. Code Officer Brandon Norman, page 11 of your agenda. Expert on the case, Carl Jones.
Brandon Norman, Citrus County Code Compliance Officer. This is case number 217-4599, construction or modification of a structure without required permits, a violation of Chapter 18, Article 1, Section 18-8, subsection A of the Citrus County Code of Ordinances. The address is 5024 East Arbor Street, Inverness, Florida 34452. Property owner is Gleason and Jonathan R. I have good service via certified mail return receipt. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A is photos taken during an initial inspection on October 17th, 2022. Photos from an inspection on November 28th, 2022. Photos taken at my compliance inspection on December 27th, 2022. And photos taken at my final inspection on January 17th, 2023. Exhibit B will be a copy of the notice of violation, a copy of the notice of hearing, and a copy of the signed certified mail return receipt.
Is there anyone from the public who's going to want to be heard on this case? Okay, let the record reflect there is no response.
Not for the playhouse. Oh. Why do you have the playhouse?
Without objection, what's been proposed as exhibits A and B are evidence.
On October 17th, 2022, an initial inspection was conducted at the property for several structures erected at the property to include a playground, shed, and carport. Research was conducted in Hanson and it was determined that no permit had been applied for any of these structures. I was able to contact the property owner. He began removing the unpermitted structures from the property, beginning with the playhouse. He has remained in contact with me throughout the entire process. On November 28th, 2022, I conducted a compliance inspection and found several of the structures had been removed. Due to the progress and processes that he's been doing to rectify the situation, I gave him additional time. On December 27th, 2022, I conducted another compliance inspection and found the remaining structures on the property without permits. The property owner applied for the after-the-fact permits for the carport and shed on 3 January 2023, and they are in processing as of today. So the only thing that remains is the carport and the shed at this time.
And it is in process.
It is in processing.
Okay.
Just hasn't been finished yet, finalized.
Okay. And actually, I don't want to, is there anyone else from the county who wishes to testify on this?
I can further elaborate. Permit number 2022-18-222 was applied for in the last week of December. It has been reviewed by the plans examiner. The comments are that the plans submitted are 10 years old. There isn't much information about the structures, and the plans examiner is asking for clarification. So
okay.
It's in the review process.
What's the county's recommendation?
The Citrus County Code Code Compliance Division respectfully requests that the special master assess a fine of $50 per day along with administrative costs to begin after the date that you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask the special master to additionally find that it's respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
I adopt the county's proposed findings of fact. The property is in violation. Grant 90 days from today to abate the violation, assuming this is a reasonable time for the review. If the violation is not brought into compliance as ordered, a penalty of $50 per day will be imposed and will incorporate all the standard order provisions.
Thank you, sir.
Thanks.
Next case on the day's agenda, Richard Eugene Custard and Kevin Bracken, case number 217-6765, Code Officer Amy Becker, page 8 of your agenda. Expert on the case, Joanna Coutu.
I'm sorry.
Oh, sorry.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Good morning.
Good morning.
Amy Becker, Citrus County Code Compliance Officer. This is case number 217-6765, accessory use structures, a violation of the Citrus County Land Development Code, Section 3102A. The address is 6952 North Rim Point, Citrus Springs, Florida. The property owners are Richard Eugene Custard and Kevin Bracken. I have good service via posting of the property as well as the Lecanto Government Complex. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on November 16th, 2022. Photo taken on December 2022 of 2022, my corrective action inspection. Photos taken on December 29th, showing the posting of the property. And photos taken on January 13th, 2023 on my final inspection. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, and a copy of the posting affidavit.
Is there anyone from the public who wishes to be heard on this case? Let the record reflect there is no response. Thank you. Without objection, what's been proposed as exhibits A and B are evidence.
On November 16th of 2022, I conducted my initial inspection for LDC violation accessory uses or structures and observed a camper, 2 vehicles, and some debris. As of my final inspection on January 13th, 2023, the camper has been removed. However, the 2 vehicles and a small amount of debris remain.
That's the county's recommendation.
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day, along with administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation, and this amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask that the special master additionally find that it's the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
I adopt the county's proposed findings of fact. The owner is granted 30 days from today to abate the violation, and if that violation is not brought into compliance as ordered, a penalty of $50 per day will be imposed. Thanks.
Next case on the agenda, Sean Carpenter, case number 217-8646, Code Officer Alan Jonason, page 6 of your agenda.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do. Good morning.
Good morning. Yep.
Alan Jonason, Citrus County Code Compliance Officer. This is a repeat violation initially observed on 17 May 2022. The address of the violation is 3449 East Bear Lane, Hernando, Florida. This is case number 217-8646, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The property owner, Carpenter Sean, has been previously found guilty of the same violation at the same location on 21 July 2022, which was case number 2164722, with $0 in imposed fines. That case was abated on 23 August 2022. I have good service via posting on the property and posting at the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, findings of facts and order acknowledging compliance from previous case 2164722. Exhibit B, photos I took during my initial inspection on 27 December 2022, and photos I took of subsequent inspections on 3 and 10 January 2023, and photos from my final inspection on 17 January 2023. Exhibit C, a copy of the notice of violation and hearing sent to Carpenter Sean, a copy of the posting affidavit, and a photo of the notice of hearing posted on the property.
Is there anyone from the public who's going to want to be heard in this case? Let the record reflect there is no response. Thank you. Without objection, exhibits A, what's been proposed as exhibits A through C are evidence.
I conducted my initial inspection on 27 December 2022 and observed that the property was in violation of junkyard conditions. During subsequent inspections on 3 and 10 January 2023, I observed very little to no change to the property. I have not had contact with the property owner, and as of my final inspection on 17 January 2023, the property remains in violation.
The last hearing, apparently Mr. Carpenter testified that he helps a friend by taking junk and debris from others and various rental properties and brings them to his property where he tries to sell it. He's on a fixed income and sells and trades scrap items for extra income. Okay. I remember this case. You haven't had any subsequent contact with Mr.
I have not.
Carpenter? Okay. What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $150 per day, along with the administrative cost to begin on the date of the posting of the property, which was 5 January 2023, and continue until 17 January 2023. That would be 13 days at $150 per day, totaling $1,950, and a fine of $150 per day from this day forward until the violation is abated. We would also ask that the special master find that it is the respondent's responsibility to notify the Code Compliance Division when the violation has been abated in order to allow for reinspection.
I adopt the county's proposed findings of fact. There will be a $150 per day fine from January 5th through yesterday. And there will be a fine of $150 per day from today's date forward, as long as the violation exists. And that fine will be recorded and constitute a lien on the real or personal property of the owner, and I incorporate all other standard order provisions.
Thank you.
Thanks.
Next case is on the agenda. Stephen Jagir, case numbers 2176854 and 2176855. Code Officer Alan Jonason, pages 9 and 10 of your agenda.
Alan Jonason, Citrus County Code Compliance Officer. I have two cases. Case number 2176855, unlicensed inoperable vehicles, a violation of Chapter 20, Article 4, Section 20-41 of the Citrus County Code of Ordinances. And case number 2176854, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address is 5303 East Live Oak Lane, Inverness, Florida. Property owner is Gajir, I hope I'm saying that right, Stephen. I have good service via posting the notice of hearing on the property and posting at the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during an initial inspection on 21 November 2022, compliance inspection photos from 27 December 2022, and photos of my final inspection conducted on 17 January 2023. Exhibit B, a copy of the notice of violation, copy of the notices of violation, copy of the notices of hearing, a copy of the posting affidavits, and a photo of the notices of hearing posted on the property.
Is there anyone from the public who wants to be heard on this case? There is not. Okay. Okay. Without objection, what's been proposed as exhibits A and B in each case are admitted as evidence.
On 21 November 2022, I conducted an initial inspection and observed the property to be in violation. On 21 November 2022, a notice of violation was issued for junkyard conditions and unlicensed inoperable vehicle, which is a violation of the ordinances listed above. On 27 December 2022, I conducted a compliance inspection and observed that the property remained in violation. I have not had contact with the property owner, and as of my final inspection on 17 January 2023, the property remains in violation.
It appears that most, if not all, of the junk is associated with I mean, I'm just having a conversation here.
Yes, sir.
It appears to be associated with, I guess one might call it expressions of artistic creativity and
maybe
yard art, or but even more than yard art. You know, really, I don't know if I'm smart enough to determine whether this is sophisticated or not. All I can say is I don't understand much of it.
It's intriguing.
It is. It's very intriguing. And, you know, I think about a lot of ancient art that is equally as intriguing that I don't necessarily understand. They just figured out what the dots meant on certain cave paintings, and I wonder if this person is onto something here. You know, some of it, I mean, it doesn't appear to be associated, but then again, I don't know. Have you had contact with the owner?
I have not. No, sir.
The unlicensed vehicle one is easy. Okay. What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $100 per day per violation, along with the administrative cost to begin after the date you deem sufficient to abate the violations. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violations and the respondent's actions relative to the violations. We would also ask that the special master additionally find that it is the respondent's responsibility to contact the Code Compliance Division when the violations have been abated in order to allow for reinspection.
I suspect that the county is probably right that this is a violation of the junkyard debris section. I mean, but here's why I'm hesitant. There was a code enforcement case in Mount Dora. I don't know if y'all are familiar with it, but it was, it lasted for years. Starry Night. And, there was a technical violation. They had painted the walls of a commercial building. I think it was a commercial building downtown. Oh, it was a home, even worse. So, yeah, if it was commercial, they might have been fine, but it was a home. And long story short, there's a new code enforcement special master in Mount Dora now, and there's a new city attorney there, and they lost a lot of money on that because the owner fought it and said, look, I've got the right to paint my house the way I want to paint it.
Sure.
I think there are different issues here, but what I'd like to ask the county, I'd like to continue this case and ask the county to possibly brief the differences between this and the Starry Night case, as well as why it shouldn't be like an exemption under some kind of lawn art.
See,
maybe you can tell me.
In my opinion, I have people can express themselves however they want.
Yeah.
I'm not necessarily wrapped around the axle, and I don't think the county is about
Yeah.
the verbiage.
Right.
I think it's the junk and debris that's on the property.
I know, and that's why
there's household trash scattered all over.
That's why I suspect you're right. And I could go through these photos and distinguish between the isolated items that don't appear to be tied to that, but I don't want to leave the county hanging and take the easy way out if I can get the answer right. And if I can also avoid you guys from doing something wrong. I mean, I just don't know.
Yes, sir.
I'm only loosely familiar with that case. It sounds like Miss Antrim is more familiar. I know the new code person in Mount Dora, and he's, very careful about this.
Sure.
So I just want to make sure we do it right. So I'm going to continue this to the next hearing.
Okay. Thank you.
Thanks.
The other one, what about the?
Oh, I'm sorry. And so on case number 2178-6855, I'll find that the property is in violation, grant 60 days from today to abate the violation, and a penalty of $100 per day will be imposed if it's not brought into compliance as ordered.
Thank you.
Thanks.
Next case on today's agenda, Edward Scott Howick, case number 217-7463. Code Officer Amy Becker, page 14 of your agenda.
Amy Becker, Citrus County Code Compliance Officer, case number 2177463, abandoned, unserviceable, and unlicensed vehicles, a violation of the Citrus County Code of Ordinances, Chapter 20, Article 4, Section 20-41. The address is 100 South DeSoto Street, Beverly Hills, Florida. The property owner is Scott Edward Hollweg. I have good service via posting of the property as well as the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on November 29th, 2022. Photos taken on December 22 of 2022 at my corrective action inspection. Photos taken on December 28th showing the posting of the property. And photos taken on my final inspection on January 13th, 2023. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, and a copy of the posting affidavit.
Is there anyone from the public who's going to want to be heard on this case? Let the record reflect that there is no one.
Am I living? Yes. Oh, I see. Cars are coming. Yeah. There
Without objection, what's been proposed as Exhibits A and B are evidence.
On November 29th of 2022, I conducted my initial inspection for abandoned, unserviceable, and unlicensed vehicles and observed a boat with an expired registration, which is a clear violation of the ordinance listed above. As of my final inspection on January 13th, 2023, the boat remains.
Okay. What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day, along with administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation, and this amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask that the special master additionally find that it's the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
Have you had any contact with the owner?
I called him twice. I called him, the last two calls were January 13th, and the last call was at 4:15 p.m. And I posted his front door, but you can't leave a message because his mailbox has not been set up yet.
Okay. Then I adopt the county's proposed findings of fact and will grant 30 days from today to abate the violation. If the violation is not brought into compliance as ordered, a penalty of $50 per day will be imposed. I otherwise incorporate all standard provisions of the order.
Thank you.
Next case on the day's agenda, Rio One LLC, case number 2174834. Code Officer Brandon Norman, page 19 of your agenda.
Good morning, Brendan Norman, Citrus County Code Compliance Officer. This is case number 2174834 for abandoned, unserviceable, and unlicensed vehicles, a violation of Chapter 20, Article 4, Section 2041 of the Citrus County Code of Ordinances. The address is 9521 East Oak Court, Floral City, Florida, 34436. Property owner is listed as Rio One LLC. I have good service via certified mail return receipt. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A is photos taken during an initial inspection on October 21st, 2022. Photos taken at my compliance inspection on November 28th, 2022. And photos taken at my final inspection on January 17th, 2023. Exhibit B is a copy of the notice of violation, a copy of the notice of hearing, and a copy of the certified mail return receipt.
Is there anyone from the public who wants to be heard on this case? Record reflect, there is none.
What's your address?
Without objection, what's been proposed as Exhibits A and B are evidence.
On October 21st, 2022, an initial inspection was conducted of the property. I was invited onto the property by the tenants at the time. We have another active case for an unsafe structure there due to that inspection. I also noticed the unlicensed vehicles at the property, and so they were found to be in violation of the mentioned ordinance. I observed the RV. It appeared to be inoperable after being invited. Like I said, it appeared that the front right wheel was, or the front left wheel was missing completely. I couldn't observe it at all. They stated it was going to be towed off the property soon. I conducted a compliance inspection on November 28th, 2022, and observed no change. At my final inspection yesterday, it appears that the property owner has now evicted the tenants from the property. The structure is actively being removed for the other case. The RV was moved, but not off the property, so it should be, they said it should be removed by the end of the week.
Okay,
So,
what's the county's recommendation?
Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day, along with the administrative cost to begin after the date that you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask the special master additionally to find that it is the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
I adopt the county's proposed findings of fact. The property is in violation. The owner is granted 30 days from today to abate the violation. And if the violation is not brought in compliance as ordered, a penalty of $50 per day will be imposed.
Thanks, sir.
Thanks.
Last case for the day, Thomas J. Thornton, case number 2176447, Code Officer Amy Becker, page 25 of your agenda.
Amy Becker, Citrus County Code Compliance Officer. This is case number 217-6447, excessive growth and accumulation of vegetation, a violation of the Citrus County Code of Ordinances, Chapter 20, Article 6, Section 20-61. The address is 229 South Barber Street, Beverly Hills, Florida. This case was continued from December 21st, 2022, special master hearing. The property owner is Thomas J. Thornton. I have good service via posting of the property as well as the Lecanto Government Building. I would like to authenticate the following documents.
Did I continue it, or was
yes,
that? I
we
did,
continued
okay.
it. We had so many, actually, we had so many cases. Remember, we had
Oh, that
two.
was the one? Okay.
Well, there's a couple, but some abated. But this
Gotcha.
was one of them.
Okay. Right.
I would like to authenticate the following documents and request that they be admitted to evidence. Exhibit A, photos taken during my initial inspection on November 8th, 2022. Photo taken on November 29th, 2022, and my corrective action inspection. Photos taken on January 3rd, 2023, showing the posting of the property with a letter advising the hearings rescheduled to January 18th of 2023, and photos taken on my final inspection on January 13th, 2023. Exhibit B, a copy of the notice of violation, a copy of the letter advising the hearings rescheduled to January 18th, and a copy of the posting affidavit.
Is there anyone from the public who wishes to be heard on this case? Let the record reflect there is no one.
Take it, they didn't get the grass between us. Oh, what you doing in Bulgaria?
Without objection, what's been proposed as Exhibits A and B are evidence.
On November 8th, 2022, I conducted my initial inspection for excessive growth and accumulation of vegetation and observed grass in excess of 18 inches, which is a clear violation of the ordinance listed above. As of my final inspection on January 13th, the grass remains in violation.
Okay. What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the Special Master assess a fine of $50 per day, along with administrative costs, to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask that the Special Master additionally find that it's the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
I adopt the county's proposed findings of fact. The property is in violation. I'll grant 14 days from today to abate the violation. If the violation is not brought into compliance as ordered, a penalty of $50 per day will be imposed. Thank you.
Thank you.
And that was the last case?
Yes, sir.
Okay. The time is 11:39 and this hearing is adjourned.